Evening all. Shall we wait for a few more minutes or shall we start with the class? Okay, let's begin anyway. So we had discussed parties to the suit yesterday, and today we'll continue with Order 1, Rule 10, and we'll finish that order, and after that we'll move to Order 2, which deals with frame of suit. So uh, Order 2, Rule 2 is very important. That is asked frequently in the examination, even if you're not appearing for any examination. If you are willing to learn for the practical purposes also, it is very important. So be very careful while we are going through Order 2, Rule 2. We'll start with Order 1, Rule 10, and for that I'll share my screen with you. Visible and audible? Someone confirm?
Yes, sir.
Okay. So Rule 10. Rule 10 is nothing but a continuation of the earlier discussion that we were having. That if in a suit the name of the plaintiff has been inserted wrongly, or it is doubtful that who is actually the plaintiff, who is actually the what is the name of the plaintiff, and that insertion of wrong plaintiff or wrong name of the plaintiff, if it is bona fide and necessary for the determination of real matter in dispute, then the court may order for substitution of such plaintiff or addition of a different plaintiff altogether. So it is again an enabling provision which says that ଯଦି ଗୋଟେ suit ରେ ଗୋଟେ plaintiff ଟାର ନା ଭୁଲ ରେ add ହେଇଯାଇଛି, or it is doubtful who is the correct plaintiff, and say jo mistake, that mistake that has been committed is bona fide, that is an honest mistake, then if it is necessary for determining the real matter in dispute, then the court can very well order for substitution or addition of such plaintiff. That is what Order 10 or Order 1, Rule 10, Sub Rule 1 says. Now, coming to the rule, Sub Rule 2 of Rule 10, that says that it is nothing but a continuation again. It says that court can suo motu or on an application. Suo motu means from its own volition. Court jodi chahibo nije kimba gote application jodi if it is made that that a party which is necessary to be added, or which ought to have been added or joined, and whose presence is necessary to enable the court to effectually and completely adjudicate upon and settle all questions involved, then the court can go ahead and add a party. And similarly, it can strike down a party if that party is improperly joined. So basically, ଆମେ ଯେତେବେଳେ ପଢିଥିଲେ ସେ ଯୋଉ proper party, necessary party, suppose ସେଥିରେ ଲେଖା ହେଇଥିଲା ଯୋଉ ଆମେ ପଢିଥିବା ଯେ ଯଦି ଗୋଟେ necessary party and proper party ଅଛନ୍ତି, necessary party if it is not joined, then the court suit will fall, suit will be defeated. But that is not the case actually. To be very practical, the court does not always right away dismiss the suit. Yes, dismissing the suit is a course that is open to the court if the necessary party is not added. But if the necessary party is not added, either the court can allow an amendment under Order 6, Rule 17. It can also add a party under Rule 10 of Order 1, and the course of dismissing the suit is also open. So court पाखरे तीनटा course open जेतले गोटे party either wrongly add हे जाईची जे कि add होबा कथा नो किंबा add होबा कथा किंतु add हे. In that case there are three courses of uh, uh, three courses available to the court. That is, one is either it can allow the amendment to be filed by the parties, either it can strike down or add any party, or it can dismiss the suit as the case may be. Next, the sub rule 3. It says that if such persons which are to be added are disabled persons, that means if it is a minor person or a person of unsound mind, then they will be added only along with a next friend. That when we will be studying the concept of how the minors special provision is given to the minors, indigent persons, unsound persons, all of that when we'll study this concept of next friend. So next friend mane guardian. So whenever a disabled person is to be added, is to be added only with a next friend, and that next friend's consent has also to be obtained before he is added. So basically, you have whenever you want to add a disabled person, you have to find the next friend, you have to take the consent of that next friend, and then you have to add that next friend. Then only the suit will be good to go. Then the next sub rule is that if the defendant is added, then the plaint will be amended. For example, in a suit, the defendant, if there is a new defendant who has been added, then the plaint will be amended. The plaint will be allowed to be amended, and the summons and plaint, the amended plaint, will be served on the new defendants. So the reason is very simple, because the new defendant is now added. He is not aware with the suit. That's why the summons along with the amended plaint, amended consolidated plaint, will be served on the new defendant, so that he'll be knowing what is the suit that he is defending. And also, if the court wants, it can also be served on the original defendants who were there in the suit already. Now the next sub rule says, when will it be deemed that the proceeding has begun? So for a new defendant, the proceeding will begin only on the service of summons on the added defendant. The outer kian nua defendant add heiji, tale ame koi pare je jebetu nua suit ta institute heitala sebe only se suit ta begin heiji or proceeding ta begin heiji. No, only proceeding will be deemed to begin on the service of summons on the added defendant. What is the reason? Because he has to also file a written statement, and we had studied that for filing a written statement you have only 30 days, or it can be extended to 90 days. Of course, it can be extended to further period also if special circumstances are given. But then there is this rule of 30 or 90 days, or any extended period as the case may be. So for that matter, say the କହିବ ଯେ ଆପଣ ଯେବେଠୁ original suit ହେଇଥିଲା ସେବେଠୁ 90 days ପଳେଇଲାଣି, so the new defendant will be precluded. No, you can't do that. Only when the summons is served on the newly added defendant, then only the proceeding will be deemed to begin. Say period ru apna 30 days, 90 days as the case may be, you will count. Now coming to rule 11, it is saying it is not important that court can give the conduct of a suit to any person. Now gode kaku jodi chahibo court ta koi paribo je ei suit ta ku you conduct. It can do that. Rule 12 is one or more plaintiff or defendant can appear, plead or act in any suit or proceeding. That means that gote suit re jodi dita defendant dita plaintiff achanti, ताले तांका चारटा प्लेंटिफ अछन, चारटा प्लेंटिफ रु सब बेले सब प्लेंटिफ आसी की अपियर करी की प्लीड करिवा कि एक्ट करिया दरकार नै. सपोज गोटे प्लेंटिफ जदी रिटन ऑथराइजेशन नै आसीबो अदर प्लेंटिफ्स को टू, then he can very well appear, plead or act in their behalf. Similarly, यदि there are more than one defendant and they on their behalf गोटे defendant आसी की appear करिया चाहूची or plead करिया चाहूची or act करिया चाहूची, then गोटे written authorization on their behalf can be obtained, and one of such plaintiff or defendant can appear in their behalf. Next is rule 13. Sei kotha am jenti padthile je objection as to non-gender or misgender should be taken at earliest opportunity and before settlement of issues, unless ground of objection has arisen later. सो जते भी आपण नॉन जेंडर गोटे पार्टी जॉइन हेनी बोली आपण ऑब्जेक्ट करिया चाहउछंती जे नेसेसरी पार्टी किमा प्रॉपर पार्टी जॉइन हेनी कि गोटे जे कि नेसेसरी पार्टी नुआ प्रॉपर पार्टी नुआ यू हैव जॉइन्ड दैट मिस जॉइन कर दिछंती आपण सो दैट ऑब्जेक्शन हैज टू बी टेकन एट द अर्लीस्ट अपॉर्चुनिटी जेतले आपण पारे अर्लीस्ट आपण व्हेनेवर यू केम टू नो अर्लीस्ट अपॉर्चुनिटी माने कोन व्हेनेवर यू केम टू नो अबाउट दिस सेम आपण सेबे ही जणया को पड़िबो आपण तापन नो जे यू कैन देयर इज नो टाइम लिमिट हियर अर्लीस्ट अपॉर्चुनिटी you have to file for that objection as to non-gender or misgender as the case may be but yes the provisos is that the what is the rule that it has to be filed before settlement of issues purburu file karahabo but unless the objection is arising the ground of objection is arising later for example settlement of issues for a amendment helani so सेठी amendment करी गोटे अलगा गोटे के पार्टी जॉइन हे गेलानी और क्या और फाइंड आउट कले कि जे other party who has purchased this thing he is now the other party has died and the legal heir who has to represent has not been joined so in that case the ground of objection is arising later then also that settlement of issues for a b you can raise that objection and then if you are not taking that objection on the earliest opportunity then it will be deemed to be waived it will be deemed as if you have not taken that objection and you are not willing to take that objection at all so that will be the end result कि आपण को allow ही कराबनी to take that objection later if you are not taking it at the earliest opportunity and before settlement of issues unless the ground of objection has arisen later so this completes our discussion on the order 1 now we'll move to order 2 that is frame of suit so now we studied pleadings how a plaint is written how a written statement is filed how then we studied the set off and counter claim if any can be claimed in the against that plaint then we studied who are the parties to the suit and how they will be added and how a misgender and non-gender effects now we'll go to the frame of suit that how the suit is to be framed suit ta betale asila plaint dela written statement dela सब dela तो एबे आपण फ्रेम केमती करिवे से जो से फ्रेम करिवा कथाटा को ऑर्डर 2 कहूची ऑर्डर 2 रा ऑब्जेक्ट इज ओनली twofold that is to afford ground for final decision upon subjects and dispute that से ताकू जेमती जहां भी dispute उडा अछि ता ऊपरे finality आसी जाउ and second is to prevent further litigation concerning them that एक तो होची फर्स्ट जहां dispute आपण भीतर अछि जहां controversy आसी ता ऊपरे there should be a finality and then the next is that there must be end to the litigation and there should not be any further litigation that is the object so it says that order to rule 1 says probably missed out writing the had written that yes order to rule 1 says that suit jitla frame hochi tar object hi hai so rule 1 is saying about the object only that what are the objects of why a suit will how a suit will be framed a suit will be framed keeping in mind the following objects that is to afford ground for final decision upon subjects in dispute and to prevent further litigation concerning them so jitla suit ta frame hochi you have to keep this in mind while framing the suit that jab finality he jao आउ केबे भी litigation or other litigation no asu से करी के अपन suit ta frame करिवे so while doing that what rules we have to follow that have been discussed in the following rules that through सबोड important होची rule 2 which says that the suit has to include the whole claim whatever claims you have to include all of it while filing the suit the object is again very simple that the defendant should not be vexed twice that one of our friend actually asked this question that what is the difference between res judicata and the principle of defendant should not be vexed twice so we'll discuss that later now coming to the object of this rule that is that defendant should not be vexed twice and the multiplicity of litigation that should be avoided as well and it is attracted when the plaintiff omits to raise all the reliefs that he has in a suit. So basically, whatever claim you have, or whatever claims you have, or whatever relief you have, basically, claim means relief. Whatever relief you are claiming, or whatever reliefs you are claiming, all of such reliefs or relief as the case may be, they must be claimed at once. That is what Order 2, Rule 2 says. It says that suit to include whole claim of the plaintiff in respect of a cause of action. So basically, a cause of action is there, and you have certain claim, you have to include the whole of the claim. I'll give you an example, and that will be probably making it clear that how are you not claiming something, and how are you not making the whole of the claim. Illustration setare hi deji, very good illustration is there, that A had given B a house on rent for rupees 1000, and then rent se lokata delani 2020 re delani, 2021 re delani, 2022 re delani. So for 3 years he did not pay any rent. Now the plaintiff chose to file only the rent for the year 2022 or 21. Gote year file kala, baki guda ku se kalani. So it cause of action is same, that's a rent deini, but you did not claim all of the reliefs. Now later A will not be allowed to sue B for rent for the year 2020 and 21 as the case may be. तो ताकू अलाउ करा हबनी जे तू गोटे तते रिलीफ थिला अवेलेबल तू क्लेम करि परथन सेतले चाहिथिले 2020 21 रो, but you chose to claim only 2022 for whatever reason. Now it will not be allowed, that you will be filing a suit claiming the further reliefs that you had not claimed in the earlier suit. Of course, dominus litis principle is there, that the plaintiff is the master of the suit and all that, so he can decide what portion he wants to relinquish. But if he relinquishes such claim, or he omits to make any claim which he had, then he will afterwards not be allowed to sue in respect of this said portion. But of course, this rule does not apply when you have taken a leave of the court, that apna court ra permission aniki apna kohujandi that okay court ku sedi apna file kala ku kahile that I'm only claiming for 2020 now, later on because there is a chance of settlement for the previous years or the next years, whatever I'm not filing right now, I don't want to claim, I don't want to make a claim for those years right now. If you take a leave of the court, then later you can also file for those reliefs. So basically, suit to include whole claim of the plaintiff in respect of a cause of action. If there is a cause of action and there are reliefs, many reliefs arising out of that cause of action, you have to insert all such claims. You have to make all such claims. If you omit to make such one of such claim, or if you omit or relinquish, with a difference kono. Omit to make any such claim mane it can be either intentional or unintentional. Relinquish mane apna gote part te go relinquish करछंती, for that matter gote part te ko apna intentionally relinquish करछंती, then either it can be relinquished or you omitted to make such claim, then also you can't file any suit in respect of such claim omitted or relinquished as the case may be, if you have not done so without the leave of the court. If you have done so without the leave of the court, then you can't make any claim thereafter. It also says if entitled to several reliefs for same cause of action, then he may sue for all or any such reliefs. So it says that if he is entitled to several reliefs for same cause of action, then he may sue for all or any of such reliefs. Jodi taku ता पाखरे बहुत गुडे रिलीफ थिबा फॉर सेम कॉज ऑफ एक्शन, तटी आउट अथर क्लियर कला, तटी जदी होल रिलीफ तो डिफरेंस 1 और 2 भितर डिफरेंस कोन, फर्स्ट होची जे सेतरे आपनकर गोटे कॉज ऑफ एक्शन रे रिलीफ थिला होल क्लेम ता आपन गोटे कॉज ऑफ एक्शन रे जहां भी क्लेम करथांते आपन सेटा को आपन call you claim, you did not claim. But here there are several reliefs which are available. For example, जे आपण जति for example गोटे say example आपनको birthday party रे आपण you had made sure that someone from the singing community will come and perform. He did not come and perform. Then आपण जो specific performance ପାଇଁ करिवे और damages ପାଇଁ करिवे, both ପାଇଁ करि परिवे. So these are several reliefs for same cause of action. So you have to sue for all or any of such reliefs. You may choose that आपण सब ପାଇଁ करिया चाहउछंती, that specific performance and damages दीटा क्लेम करिया चाहउछंती किबा गोटे करिया चाहउछंती. But आपण जदि गोटे को छाडी देले without the leave of the court, then later on you can't sue for the omitted relief. So this is also the extension of that rule, which says that upon first plaintiff has to include the whole claim. The suit has to include the whole claim of the plaintiff in respect of a cause of action. And if the plaintiff is deciding to omit or relinquish a portion of such claim, then it will be he will not be allowed afterwards to sue in respect of the said portion. So here out of the concept thila that he can do so just to bring it under the jurisdiction of the court. Suppose for example, एबे मु मोर 10 वर्षर रेंट पेंडिंग अछि, मोर मासकर भडा होची 10,000 टका. So if I claim all the rent, probably it will exceed the jurisdiction of the court. So that's why I am willing to relinquish a portion of such claim just to bring it under the jurisdiction of that court. 50,000 टका कम रु आने चाहूँ. That is allowed, but आपण जदि करिवे सेटा without with leave of the court you do that is fine. But if without the leave of the court you are doing, then afterwards you will not be allowed to sue in respect of such cause of action. तार extension कोन कहला जदि गोटे cause of action रे several reliefs available अछि and आपण one of such relief आपण नेले आ गोटे नेलेनी, then whatever relief you are omitting, you can't sue for any such omitted relief if you have done without the leave of the court. It is the question comes whether the act of omission or relinquishment is intentional or not. That बहुत जण प्ली करिवे that जो omission था that was not intentional. So it does not matter the omission was not intentional. Omission माने ही intentional नो. Omission माने तो मु भूली गली माने करिलिनी छाडी देली. So that is fine. That is जदि भूली भी गली कि छाडी देली आपण doesn't matter. आपणकर intentional थाउ न थाउ, if you have omitted to do so, then you will not be allowed. But a Raman Ithi versus Papi Vaskaran case re कहला that he must have knowledge or awareness of such cause of action or relief. माने he should be knowing that I was supposed to get a relief and I did not go for it. But तार जदि knowledge रे नथिला, that is different thing. But the knowledge रे अछि that cause of action or relief, whatever the existence of it is in knowledge, and he has omitted to do so or he has relinquished it, then he will not be allowed later to file for the same relief. Now comes that whether what if there are two causes of action? What if that there are two causes of action? Will they be hit under order to rule 2 if plaintiff chooses one cause of action and leaves out the other? No, it will not be, because it is gote cause of action re dita relief darkar. It is jodi dita cause of action achi, cause of action are different, they will not be hit under order to rule 2. Next is the bar will be attracted when inclusion of the relief is mandatory and not optional. That bar se jo bar ta jo order to rule 2 ra bar ta jo koche je आपण को allow करिवानी plaintiff को परे से relief ta को claim करिवा को, that is only possible if the relief which is to be claimed is mandatory and not optional. If the optional relief thibo se claim kariya chhadini, that is fine, that will not be barred. But if it is a mandatory relief which he which he should have claimed while claiming that, then it will be hit under order to rule 2. Next is such relief must be available or arisen when the suit was filed. Union of India versus HK Dhruv re कहला that जो relief ta आपण एटा hit करिया चाहचंती under order to rule 2, that must be available or arisen when the suit was filed. suit file kala belalku jodi suppose se relief ta hi exist karunatila. For example, ଆପଣଙ୍କର ଏବେ ଏବେ ଆପଣ ସେ ଯୋଉ ରେଣ୍ଟ ଗୁଡା କ୍ଲେମ କରିଛନ୍ତି, ରେଣ୍ଟ ଗୁଡା ଆପଣ କ୍ଲେମ କରିଛନ୍ତି 2022 ର ଏତିକି ମନ୍ଥs ପର୍ଯ୍ୟନ୍ତ, ଏବେ ଫର୍ଦର ମନ୍ଥs ର ଯାହା ଗୁଡା ଆପଣ ଇଏ ଗୁଡା ଫର୍ଦର ମନ୍ଥs ର ଯାହା ପେଣ୍ଡିଂ ରେଣ୍ଟ ସେଟା ସବୁ ତ ଏବେ ଆରାଇଜ କଲା। So ଯୋଉ ଏବେ ଆରାଇଜ କଲା ଯୋଉ ରେଣ୍ଟ ଗୁଡାକ, that is not that was not arising when the suit was claimed, the original suit was claimed, then it will not be hit under order to rule 2. Next is whether order to rule 2 bars amendment. The answer is obviously no, because it does not bar amendment. You can obviously file an amendment and add any party. You can add any relief. Sorry, party. Yes, party. I'm saying you can add any relief. It does not bar an amendment. Just bars a further suit and claiming a different relief which you could have claimed in the earlier suit. Now the question comes that what is the difference between order to rule 2 and section 11, that is res judicata. So you have to know that while order to rule 2 is barring the relief which ought to have been claimed, section 11 is barring the grounds of attacks and defense which could have been taken. So basically एथरे relief गुडा को आपण बार करछन जे ए relief आपण claim करि परिबे, ए claim गुडा आपण करि परिबे. But here what are the grounds on such relief or whatever such claim you are making, such ground is barred by res judicata or constructive res judicata as the case may be. And what is the difference between order to rule 2 and 10? Order section 10 re, it is barring the trial. So trial of another suit is barred. And what will be the difference with estoppel? So if there is a bar by the act of the parties, that is a different bar altogether. Order to rule 2 is barring the reliefs, or section 11 is barring the grounds of attacks, section 10 is barring the trial, and estoppel is done by the bar imposed by the act of the parties. That finishes our discussion on order to rule 2. Now coming to order to. So it says, it's a very simple section which says that if there is a plaintiff or there are more than one plaintiffs and there are several causes of action against one defendant or more than one defendants, then they may be joined together. Such causes of action may be joined together. For example, I am a plaintiff and I want to file a case against B, and there are several causes of action arising against that said defendant. So I may join all such causes of action together. Again, this is only to make sure there is end to the litigation, multiplicity of litigation is avoided. Here, because there is chain circumstances, now the suits have because of the chain circumstances, even if there are several causes of action arising, then also the plaintiff can join such causes of action together against the defendant. Similarly, if there are more than one defendants and there are more than one plaintiffs, they also may join several causes of action if those are accruing against the said defendants and due to the said plaintiffs jointly. But how the jurisdiction will be decided? Suppose you are joining several causes of action, ताले तो jurisdiction टाको exceed कर जाई पारे, because you एबे आपण कहले कि 50,000 टका मोटू नेला फेरेलानी, बट फास्ट 50,000 टका नेला गोटे प्लेंटिफ फेरेलानी, डिफेंडेंट नेला फेरेलानी, तापर आउ थर नेला फेरेलानी बी, पुन 20,000 टका नेला वर्ष पर सेडा ही फेरेलानी, 30,000 टका आउ 2 वर्ष पर नेला ताको ही फेरेलानी. सो लक्ष टका टोटल ड्यू अछि, किंतु तीनटा कर कॉज ऑफ एक्शन अलगा, तीनटा को तीनटा देले फेरेलानी कॉज ऑफ एक्शन अराइज करछि. So several causes of action I can very well join, but jurisdiction of the court will be calculated. Jurisdiction purpose ପାଇଁ ଯେତେବେଳେ आपण calculation କରିବା, all these three will be combined and the jurisdiction will be calculated. So 1 lakh है कि probably the CJJD पाखरे आपण फाइल न करी कि CJ senior division पाखरे फाइल करिवे, but for the calculation of jurisdiction the aggregate subject matter will be considered. Rule 4 is important again. It says that what causes of action can be joined with a suit for recovery of immovable property. ଗୋଟେ suit of recovery of immovable property ଚାଲିଛି, then କୋଉ cause of action ଗୁଡା ଆପଣ ତା ଦେହରେ join କରିପାରିବେ without leave of the court। ଯେ ଆପଣ ଗୋଟେ suit of recovery of immovable property ଅଛି, ଆପଣ ତା ଦେହରେ ଆଉ ଗୋଟେ କିଛି add କରିବାକୁ ଚାହୁଁଛନ୍ତି, ସେଟାକୁ ଆପଣ କରିପାରିବେ, ମାନେ join କରିପାରିବେ କି join କରିପାରିବେ କି ନାହିଁ, ସେଟା ହଉଛି first ହଉଛି claim for mean profits or arrears of rent in respect of the same property। So basically ଯଦି ଗୋଟେ mean profit arise କରି ଯାଉଛି ସେଇ accrue କରି ଯାଉଛି ସେଇ property ଉପରେ, or ତାର ଗୋଟେ rent କିଛି ଥିଲା ଯାହାର area ଗୁଡା ରହି ଯାଇଛି, all of those you can claim in the suit for recovery of immovable property। Next is damages of breach of contract under which the property is held। ଗୋଟେ contract under ରେ ଆପଣ ସେ property ଟାକୁ hold କରୁଛନ୍ତି, and that breach of the because of that breach of contract you are claiming a damage, then for that also you can join that cause of action along with a suit for recovery of immovable property। Third is the claims in which relief sought is based on same cause of action। ଏଥିରେ ଆପଣ ଗୋଟେ cause of action ରେ ଯଦି ଏ reliefs କେତେଗୁଡା claim କରୁଛନ୍ତି, then also you can join them in the suit for recovery of immovable property। Fourth is ଯଦି ଗୋଟେ mortgage property ଅଛି ଆଉ ତା ଦେହରେ ଆପଣ foreclosure କିମ୍ବା redemption ପାଇଁ file କରିଛନ୍ତି, then if you are asking for possession, then you can very well join that possession cause of action in that suit for recovery of immovable property। You can do that is rule 4। जे को केस रे आपण without the leave of the court you can join the cause of action। ସେଥିରେ प्रोवाइजो भी अछि, से प्रोवाइजोटा मु 4 नंबर रे लिख देछि, 4 पार्ट रे लिख देछि। तो 4 चारटा जिंस आपण मन रखिया पड़िबो which you can join without leave of the court in a suit for recovery of immovable property। First is claim for mean profits or arrear of rents in respect of property, damages for a breach of contract under which the property is held, claims in which relief sought is based on same cause of action, and fourth is party asking for possession of the mortgage property in a suit for foreclosure or redemption। Now rule 5 कहला जदि गोटे person who is a deceased or तार heir किए अछि, or से गोटे trust कथला तार administrator or executor, से सब जो मान को against रे जदि तांको against रे किंबा on behalf of them a suit or a claim is filed by or against a person, then such claims must arise such claims must arise jointly with such deceased person। ता माने एग्जांपल दिले आपण बुझ परियो सेतर कोन कहूची दैट गोटे लोकटे थिला से मरि जाईची, एबे तारो लीगल एयर होल्ड करूची, मु एबे लीगल एयर अगेंस्ट रे फाइल करबी, मु जेतले एबे से लोक अगेंस्ट रे फाइल करिया कथा सेही क्लेम टाको मु फाइल करि परिबिनी लीगल एयर अगेंस्ट रे, कि लीगल एयर अगेंस्ट फाइल करिया कथा से लोक अगेंस्ट, लोक तो मरि गेलन छाडो, लोक अगेंस्ट फाइल करिया कथा लीगल एयर अगेंस्ट करि परिबिनी unless the claims arise when they were jointly liable with the deceased person। सेठी आपण जदी येटाको डायरेक्ट पडले it will be more clear that no claim by or against an executor, administrator or heir as such shall be joined with claims by or against him personally unless the last mentioned claims are alleged to arise with reference to the estate in respect of which the plaintiff or defendant sues or is sued as executor, administrator or heir or as such। Basically the principle here is that गोट लोक जदी करिनी ता पई आपण ताकू ता अगेंस्ट करि परिबेन ना, कि जदी से ताकू ड्यू हेनी ता फॉर भी करि परिबेन। सो दिस शुड बी आइदर जॉइंटली लायबल, जदी से डिसीज सहित से हेयर जॉइंटली लायबल अछि ताले ता अगेंस्ट करि परिबे। So basically that is what it says। It is not very important, you just have to know it, that's why I told you। Rule 6 is power of court to order for separate trials। It is again we had discussed कि सही भले ही that जदी such joinder of जो causes of action आपण join करले किबा reliefs आपण join करले, also things if such joinder embarrasses or delays the trial or it is inconvenient to the court, then the court may order for separate trial। So court so सबुटु important is always delayed justice is not as justice at all। So court will always ensure that how all these provisions are in fact made just to make sure that there will be end to the litigation, there will be avoiding multiplicity of litigation, there will be less number of suits, so that it can be disposed quickly and so that the justice will be effective। So if any such joinder which were the purpose of which was in fact to help the court in order to make sure there is no delay in the trial and there is no inconvenience to the trial. If it is acting otherwise, then the court has much power to order for separate trial. Rule 7 is objections as to misjoinder of causes of action. ଯଦି ଆପଣ ଗୋଟେ cause of action କୁ misjoin ହେଇଯାଇଛି, ଯୋଉଟା join ହବା କଥା ନୁହଁ କିମ୍ବା ସେଟା join ହେଇଯାଇଛି, then all such objections must be taken at the earliest opportunity again and before settlement of issues. Of course, if it arises subsequently than that of the settlement of issues, that is fine. But the objection ground ta ଆପଣ ପାଖରେ ଅଛି and you are not taking it at the earliest opportunity, then it will be deemed to be waived. This is what it says. So that probably ends our discussion on order 2. Now we'll take any questions if there are any. If there are any questions, please feel free to ask. Otherwise, we'll end the session here.
Sir.
Yes.
Sir. Order 2, rule 2, sub rule 3.
Yes.
Sir, ଟିକେ ଆଉଥରେ ବୁଝେଇଦେବେ, ବୁଝିପାରିଲି।
Order 2, rule 2, sub rule 3.
Yes, sir.
Rule 2, sub rule 3. Yes, omission to sue for one of several reliefs.
Yes, sir. Yes, sir.
Yes, so that is saying that the person entitled to more than one relief in respect of the same cause of action may sue for all or any of such relief. But if he omits, except with the leave of the court to sue for all such reliefs, he shall not afterwards sue for any relief. Basically, I think that there was one cause of action and out of that there are more than one reliefs. For example, आपन कहूची जे एग्जांपल जोड़ा देली जे गोटे cause of action माने आसे जो आपन लता मंगेशकर को साइन करथिले फॉर singing in your show, she did not come, so you had a loss. Also you want a specific performance, you want to claim the damages, also you want to claim the specific performance of the contract.
Yes, sir.
So you had two reliefs available here arising out of the same cause of action. So the plaintiff is at liberty to file for one of such cause of action, one of such reliefs. So gote cause of action to there are more than one reliefs available, but you are choosing to file one relief and you are putting away or omitting other. Then if you have done so without the leave of the court, then afterwards you will not be allowed to file a suit claiming such relief. That is what it says. That आपन को चांस थिला दीटा रिलीफ आपन क्लेम करि परथान, बट आपन काहे करलेनी? आपन सेट स्पेसिफिक परफॉर्मेंस परथानते क्लेम, डैमेजेस भी क्लेम कर परथानते, but you chose to claim only specific performance of the contract, or you chose to claim for damages only. So that was disposed. Right now, after 5 years of suit, you are again coming saying that I forgot to claim damages. No, you can't do that.
Okay, sir. Thank you, sir. Thank you, sir.
Trinath
Sir,
with us has a question. Please ask. Before that, introduce yourself.
Sir, my name is Trinath Sahu. I am pursuing LL.B at ULC.
LL.B in ULC? 3 year or 5 year?
Yes, sir.
3 year? Okay, great.
My hometown is Cuttack.
Hometown is Cuttack? Okay, great. So what was the question?
Sir, my more doubt thila je se jo Abdul Ture jo cause of singular form रे
बड़ा वेला
अधिक थिबो more than one से कोन सेपरेट गोटे सूट रे ही सब जाक कॉल टू एक्शन को इंक्लूड कर
को सब रूल 2 कहले आपन सब रूल 2 रे
सॉरी सर
रूल 2 रे सब रूल 2 रे
ना रूल 2 रे ही रूल 2 सब रूल 1 रे कॉज ऑफ जो कहि छी सेटा सिंगुलर फॉर्म रे तो जदी जनकर कॉज ऑफ मोर देन 1
So as I told you, order to rule 2 does not bar several causes of action. It bars one cause of action, but there are more than one reliefs, or there is a whole माने whole claim रो आपण किछि पार्ट छाड़ दोचंती. So दीटा पार्ट अछि से जो order to rule करे आपण आउथरे बतौची. फर्स्ट होची जे आपणकर पूरा cause of action टा was arising in respect of one property, but you claimed only respect of half of the property. So सेठी आपण गोटे भूल कले. सेकेंड होची जदि आपनकर गोटे कॉज ऑफ एक्शन रे तीन चारटा रिलीफ अवेलेबल थिला जोडा बे निश्चित पचारले आ जोडा को बुझेली जे गोटे कॉज ऑफ एक्शन रे तीन चारटा रिलीफ अवेलेबल थिला बट यू चोज टू क्लेम वन रिलीफ ओनली. सो आई हियर ऑर्डर टू रूल 2 इज कंसर्न्ड विथ वन कॉज ऑफ एक्शन एंड देयर आर सेवरल रिलीफ्स अराइजिंग आउट ऑफ और वन कॉज ऑफ एक्शन रु गोटे जोडा क्लेम करे था तदरु पार्ट टा आपण ओमिट करे कि पार्ट टा पई क्लेम करचंती. सो सेही जो omission or relinquishment of the relief or the part of the claim as the case may be, that will be hit under order to rule 2, not several causes of action. Several causes of action achi आपण severally आपण चारटा शूट करंतु. All the एटा हेची एति पय just to make sure that it is finality to the litigation and to the litigation multiplicity न हो. तामान नो जे आपण causes of action different time रे arise करूची सेठी आपनकर it will not be bound you are not bound कि आपण एटी causes of action गुडा करे आपण सब जाक मिसी कि एका सारे फाइल करिवे. सेवरल causes of action जदी अछि आपण करंतु अलग अलग सूट किछि असुविधा नै. ऑर्डर टू रूल 2 सेटा बार करनी. ओके
सर रूल 6 रे जो सेपरेट ट्रायल कथा कहला जो ट्रायल सेपरेट ला कोन से गिटाई बोली पूरा हम
कोन कहले
रूल 6 रे ट्रायल ता सेपरेट
हां आपन वॉइस से बहुत ब्रेक होची सो आई कांट हियर यू प्रॉपर्ली.
सर रूल 6 रे जो सेपरेट ट्रायल कथा सेटिंग सूट रो माने कोन रहिबो भाई सूट गोटे बोली
सीधे आपण ट्रायल माने ही सेपरेट सूट माने आपण भाबंतु नि जे ट्रायल माने सूट टा गोटे थिबो बट ट्रायल अलग अलग सेमति केन थी परबो. सूट टा अलग ही करिया गुडो ता माने आपण ता माने आपण देले व्हेन द कोर्ट कोन कहले
से सूट टा डिफरेंट माने कोर्ट में कारण सेटा माने पावर टे कोर्ट को दिया है ये ट्रायल सेपरेट.
हां
ताले से जो सूट टा थिला से सूट को सेपरेट कोर्ट
हां कोर्ट करिवो जेंति आपण भाबंतु स्प्लिट अप होची गोटे देयर इज अ प्रोसीडिंग देयर इज अ प्रोविजन ऑफ स्प्लिट अप इन अ क्रिमिनल केस. जेतले गोटे अक्यूज्ड सपोज सेवरल अक्यूज्ड को अगेंस्ट गोटे केस रे अछि सेटा तदुर गोटे अक्यूज्ड आबे आसिला कोर्ट को आ समस्त एब्सकॉन्डर हे गेले. तो कोर्ट विल नॉट वेट कि समस्त पई गोटे अक्यूज्ड काहे ना भीतर यूटीपी हे कि रहइबो प्रिजनर हे कि. तो ताकू से कोन करछि ताकू स्प्लिट अप करी कि ताकर ट्रायल टा स्टार्ट करछि. ओडा फाइल ए कर दबो सीएस सपोज सेटा जदी जीआर केस थिबो जीआर 1995 बाय 2015 ए करी कि से तार केस टा को करचंदी. सो इन दिस केस आपण ट्रायल सेपरेट करि परिबे जदी आपण देखुचंदी दिस इज ओनली दिस सच जॉइंडर इज डिफीटिंग द पर्पस फॉर व्हिच इट वाज इनेक्टेड. इट इज लाइक आपण जहा को माने जहा भाबी के आपण करथिले तार ऑपोजिट रे काम करूची. तो you are in right to actually order for separate trials. So separate trial माने सूट को आपण अबे डिवाइड करी कि दीटा को अलग अलग ट्रायल करिवे चलियो.
ओके सर थैंक यू सर.
Okay, welcome. Any other question? Is there any other question or we'll end this session here? I believe someone had raised the hand but then probably put it down. I am forgetting the name because I missed out probably. Okay, so I'll presume that there are no questions further. So we'll end the session here. Thank you, everyone.
Thank you, sir. Thank you, sir.
And on Monday we'll again start with the transfer of property. So we'll do this in alternative. So transfer of property 1 week and then CPC for 1 week. That 1 week when I say that means for 4 days, Monday to Thursday. Okay. Thank you.
थैंक यू सर.